Here's Ben Shapiro to do some bad legal interpretation.
A couple days ago, the Supreme Court came out with a decision essentially rewriting employment law in the United States. The Democrats have been trying to do this with the so-called Equality Act, but it had not gotten through Congress. So Justice Gorsuch and a 6-3 majority of the Supreme Court decided, hey, why not do it ourselves? And we'll just rewrite the Civil Rights Act of 1964 to pretend that the Civil Rights Act of 1964 included sexual orientation and transgenderism, concepts in the case of sexual orientation that clearly were not included, or in the case of gender identity that nobody had ever heard of because it's crazy.
These things are, in fact, included in the law, even if the folks who wrote the law didn't realize this to be the case. Saying that they're not in there is like saying that Pythagorean theorem wasn't true of right-angled triangles before Pythagoras figured it out. Whoever first came up with the idea of those triangles probably had no idea that the square of the hypotenuse was equal to the sum of the squares of the other two sides, but that doesn't change the fact that it is inherent to the concept. The reason why discriminating based on orientation is the same as discriminating based on sex is because if you allow employees of one sex to date men, but you don't allow employees of another sex to date men, then you are treating the sexes differently. With respect to transphobic discrimination, if you allow some employees to use a set of pronouns, but not others, and you base that distinction on what you regard to be their sex, then you are discriminating on the basis of what you regard to be their sex.
The fact that I think it's pretty obvious that this is a bad legal decision, that the Civil Rights Act did not mean to encompass sexual orientation.
It doesn't matter what it meant. At least it doesn't matter to Gorsuch. He's a textualist. Textualists believe that what matters is what the law literally says. That is the only way to avoid legislating from the bench. If you interpret a law based not on what it plainly says, and instead based on your speculations about what the legislators meant it to say, that is rewriting the law. That would be legislating from the bench, because you'd be rewriting the law to say what you think its legislators wanted it to say, rather than applying what it actually says.
And it certainly did not mean to encompass men who believe they are women.
Ben, if you didn't already know, thinks trans women are men who believe they are women.
Because it seems that Title VII is now in direct conflict with Title IX. Title IX protects biological women.
The term biological women appears nowhere in Title IX. In fact, the word women never appears in it. What it says is, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. In other words, educational institutions receiving federal funds cannot deny you benefits or discriminate against you based on anything having to do with which kind of reproductive system you have. The point is not to protect anyone with any particular biology. The point is to take biology out of the equation. That's entirely consistent with Gorsuch's interpretation of the Civil Rights Act, because both laws, under Gorsuch's reading, prohibit telling someone with one reproductive system, or whatever you're using to judge someone's sex, that they're allowed to ask to be referred to by a certain set of pronouns, while telling someone with another reproductive system that they're not allowed to ask to be referred to by those same pronouns.
And apparently Title VII now requires biological men to be treated as biological women if they so demand.
Both the Civil Rights Act and Title IX say that a person's reproductive system ought not be a basis for denying a person's request to be treated in a certain way.
Which is bizarre. What are the actual ramifications of this decision for employers in the United States?
That there will be consequences for having bigoted employment practices.
Yeah, I think you're going to see the collision you just mentioned between Title VII and Title IX. I think that's going to be answered by saying that Title IX, when it bans discrimination on the basis of sex, that means, according to Gorsuch, a man who identifies as a woman, if you don't treat him as if he's a woman, you're discriminating against him on the basis of his sex.
That's the conservative way of framing discrimination against trans women. They think that trans women are men who are just saying that they're women. They believe that this conflicts with Title IX because they think that Title IX does not and should not protect trans women.
You know about hostile workplace doctrine? So if you are an employer and someone refuses to use the preferred pronouns, that could foster a hostile workplace, and you as the employer will now have a legal duty to make that employee use the preferred pronouns or to get rid of that employee.
The most consequential interpretation of these laws would probably be that if an employer not only refused to use the pronouns an employee requested, but also insisted on deliberately using pronouns that the employee asked the employer to not use, then maybe that could be seen as creating a hostile workplace. But why shouldn't it be? That seems to me like it would be as severe a form of bullying as referring to an employee by an ethnic slur, and therefore ought to carry the same legal consequences.
Right? There are going to be all sorts of litigation that follows from this because, as you said, the court just rewrote the law.
I mean, that last point is such a telling one, because the entire logic of the court is that transgenderism is protected under sex discrimination because you're discriminating against a biological male because he's a biological male if he says that he is a woman, correct? So you're discriminating against him as a man, not as a woman. You're discriminating against him as a man. But if you say that he's a man, you may be violating law now.
That is exactly right. That is the logic. I mean, there's a simplistic logic to Gorsuch's opinion.
Yeah, it's the most obvious reading of the law. The more convoluted the logic you use, the greater the danger of reading something into the law that isn't there. If you don't want the Supreme Court rewriting laws, then the simplest logic is the logic that should always be applied.
Where he says, if the employee, or by extension, the student, would have been treated different if the employee or student were a different sex, that's an instance of discrimination on the basis of sex, right? So what he's read into the law is androgyny, right? He's read into the law that we can take no account of the biological differences between men and women, boys and girls. Otherwise, we're discriminating on the basis of their sex. And that's not what Title VII or Title IX required. It said you can't have double standards. It didn't say you can't have any standards at all.
Any unfair standard which applies in different ways to different people is a double standard. Also, it's funny that these conservatives are wringing their hands about this decision undermining Title IX when they never really cared much for Title IX to begin with.
So the real question for religious institutions is obviously how the Supreme Court draws the lines there, because where we're going to see the most conflict, aside from the free speech issues. I mean, first of all, it seems to me entirely bizarre that free speech doctrine would allow laws that prevent me from saying a biological fact. Like that's an incredible, incredible thing. The idea that free speech doctrine would would force me to be fired or create legal liability on the basis that I have said something that is a biological fact. I mean, I guess maybe the Supreme Court upholds that idea, that if I say that a transgender male is in fact a woman, that I can now be I must be fired from my job or disciplined in some way. That is now federal law, does not violate the First Amendment. Like how that is possible is beyond me, but
Well, I disagree that misgendering someone is simply stating a biological fact. A person's gender, and thus what pronouns they ask you to use, do not always correlate to a particular biology. But even if it were simply stating a biological fact, it would be analogous to giving an employee an unwanted nickname that references their skin color. That the nickname would be referencing a biological fact doesn't make it any less an expression of hostility that is inappropriate for a workplace.
Healthcare plans, another big case last week. Trump's HHS finally, 3.5 years later, fixed a bad Obamacare mandate that would have mandated coverage of sex reassignment procedures, would have mandated hospitals and doctors perform these procedures. It's unclear now what the law is going to be on this in light of the Title VII ruling.
Hopefully, the consequences will be that denying doctor-prescribed care is no longer allowed.
Basically, Gorsuch has broadened LGBTQIA employment rights, but that he is about to carve out all sorts of significant religious exceptions to that rule. I hope that's the case, but it also does backfoot virtually all religious people in the country by essentially suggesting the only reason that you're quote unquote allowed to be a bigot is because you're religious. And this is a case that you've seen from Cory Booker and Beto O'Rourke, which is that religion is actually just cover for bigotry. You can't have any good faith reason, for example, not to want your third grade child taught by a man who believes he's a woman.
What non-bigoted reason could a person have to oppose trans people teaching third grade? Do you oppose trans women teaching your children because you believe that believing oneself to be a gender that's different from the one originally placed on one's birth certificate is a mental illness, and that this means that they are a danger to your children? To believe that is to be irrationally prejudiced against both trans people and people with mental illnesses. Do you believe that they are simply not competent to teach because you think that believing oneself to be a gender that society traditionally says does not match one's body type is false? In that case, you were guilty of the prejudice that presupposes claims about one's gender to be claims about one's biology. I can't think of any reason to oppose trans people being teachers that doesn't assume some prejudice about trans people.
That the only reason that you'd want to do that is because of religious bigotry, and the only way you can get out of it is by invoking your religious bigotry. It seems that Gorsuch made a decision that is not just a decision about the interpretation of law that is faulty, but a decision about human nature itself that utterly denies the reality of sex entirely.
If you think that a person's reproductive organs can never fail to correlate to a particular gender identity, then you are the one denying the reality of sex. The biological reality is that people with insemination physiology can be any gender, and people with gestation physiology can be any gender. To deny that is to deny biology.
If you look at what Justice Ginsburg has said about sex discrimination in the past, she should not have sided with Gorsuch in this case. In the amicus brief that I filed on this case, I point out that Ginsburg said sex discrimination requires double standards. It's when you hold women to one standard that you don't hold men to. But this was the same standard for all men and women, right? No one can cross-dress at work, whether you're male or female.
First of all, trans people are not cross-dressing. They are dressing according to their gender identity. Secondly, even when it comes to actual cross-dressing, a rule against it does, in fact, constitute a double standard. Because what it means for any particular person to cross-dress depends on at least two things: what they are wearing and whether they are a man or a woman. If a man wears a dress, that's cross-dressing, but if a woman wears a dress, it's not. Therefore, a rule against cross-dressing creates a standard that does not apply the same to men and women. By the way, this argument is also analogous to an argument that folks who defended laws against miscegenation made. They said that laws against interracial marriage aren't racist because all races are prohibited from marrying outside their race. That argument is nonsense too.
Men can't be wearing dresses. Women can't be wearing coats and ties. The case involved a funeral home director, right? And there was a dress code here.
I guess the reasoning here is that if you have two double standards, one invidious to men and a different one invidious to women, the two cancel each other out. This is absurd. As the court wrote, if an employer fires a man for not acting masculine enough, but also fires a woman for not being feminine enough, in both cases the employer fires an individual in part because of sex. Instead of avoiding Title VII exposure, this employer doubles it. Banning men from wearing dresses is not made less bigoted by banning women from wearing ties. If you do that, all you're doing is being bigoted twice. To everyone who helps me out on Patreon, you're a big help. Thanks so much.